Good morning, everyone. We're going to give everybody about one more minute to join us. Erin is not here this morning, but we will let Sarah begin in just about a minute. We'll give a little more time for everyone to continue to join in. All right, Sarah, I think it's looks like the waiting room is slowing down a little bit. I think if you want to go ahead and share your screen and get started.
Okay. All right. I need to get my slideshow to start here. Perfect. No, not so perfect. This is the thing I can never figure out. When the little bar is on top of your screen, it makes it hard to get to the bar for your own little thing. So I have to like maneuver it around until I can get it to the position that I want. There, see, this is what happens. All right, so as you can see, FAPEcat was doing his thing a few minutes ago. He's been very busy in this holiday season. He has a little human that he needs to shop for, and he was not pleased because I hadn't ordered the book that he wanted to send his little human yet. Apparently the little human is into fire trucks this year, so FAPEcat is getting him Pickles the Fire Cat, a favorite book for cat lovers and fire truck lovers. Anyway, it's week 4, and we have finally gotten to FAPE. Yeah, you would think it would be a little sooner that we would get to FAPE, but as you know, I'm very linear, and so there was a lot of stuff that had to happen before we could finally get to FAPE. But we're here. And so today, we are going to talk about being at the point in the IDEA process where you must develop the IEP. So we've already located, identified, evaluated the student, and determined that they are eligible under IDEA. And just so that we're clear, once you've determined eligibility, there is an entitlement to FAPE. So if you've done the evaluation process and you've had the IEP team meeting, you've determined that yes, this is a child with disability, the next thing to do is develop an IEP, which then has to be implemented by CDS in the least restrictive environment. Also to keep ahead of, the timeline is going to continue, right? As you're working through the IEP development process, you have to remember that you have a timeline to reckon with. Okay, so a free, appropriate public education. When the Supreme Court got its first case in 1982, talking about what was a free, appropriate public education, they were a little bit surprised. Why do you need to know, they asked, what a free, appropriate public education is when the statute, the IDEA, simply tells you? The statute says FAPE means special education and related services, that are provided at public expense, under public supervision and direction, and without charge, that meet the standards of the state education agency, that include an appropriate preschool, elementary, or secondary education in the state involved, and that are provided in accordance with an IEP that meets the requirements of IDEA and its regulations. So it's simple, the Supreme Court said, right? Not so much. Not so much. And the litigation history suggests that, in fact, really nobody knows what a FAPE is. Now, that's a little harsh, but it does sort of prove that in some ways FAPE is truly that thing that's in the eyes of the beholder. In other words, if you ask a family that's satisfied with the services their students are getting, they'll say, yep, that's FAPE. And if you ask a family that is, of course, unsatisfied with the services their student is getting, they are sure that that's not a FAPE. But how would anyone know as between the two? So here's how we're going to tackle the project. This week, we're going to talk about the procedural requirements that go into creating and implementing an IEP. And then second, next week, in the big pre-Christmas showdown, we're going to talk about the substance. What is it that makes one IEP deliver FAPE and another IEP not? And then we're going to take 2 weeks of vacation, because clearly after 2 solid weeks of dissecting FAPE, let's just say we need a little time to recollect ourselves. Okay. Free. Special education and related services on the IEP have got to be provided at no cost to the family. Now, there's an exception to that. Incidental costs and fees that are charged to all students, regardless of whether they have a disability, are okay. So my best example of this, which doesn't apply really in the CDS context, but perhaps if one of your students was attending a regular education preschool operated by a school district, and they were going to do a field trip to the local animal farm. Yeah, not during the pandemic, but again, we're looking big picture here. And so every student needed to pay $5 to go on the field trip to the animal farm. It's okay to charge a student with a disability the $5 to go to the animal farm, because that is an incidental fee that's charged to all of the students who are going on the field trip, regardless of whether or not they have a disability. On the other hand, a district that shall remain nameless wanted to charge a student with a disability $75 to go on a field trip with their typically developing classmates, because they needed to have a one-to-one aid with the student at all times. Can you do that? Of course not. Of course you can't charge a special fee because of any extra need that a student with a disability might have in order to access what all their classmates were doing, going on the field trip. So, another part of the free discussion. Public agencies can access public or private insurance along with having parental consent to do that. IDEA funds are what we refer to as the, quote, payer of last resort. In other words, you pay with special education funds for things that there is no other funding available for, and to ensure that the parent receives the services at no cost. So, public or private insurance. In Maine, public insurance is MaineCare. That's what we're talking about here. And of course, private insurances can be whatever insurance the family has purchased or is obtained through one of the parents' jobs, et cetera, et cetera. Before you access public or private insurance, you need to get parental consent. And if you remember from last week when we talked about consent, it has to be knowing consent. In other words, you have to review with the parent what, if any, consequences there are of providing access to public or private insurance. You would explain to them that means disclosing information about the services that their child is receiving to the insurer, whether it be main care or a private insurer, so that you can engage in billing, right? It would also perhaps mean that they might have to pay, with respect to private insurance, a copay. And in that case, CDS could, in order to make it free, agree to absorb the copay in order to obtain the private insurance benefit and thus not be on the hook for the whole amount. But remember, parents have the right for it to be at no cost. With public insurance in Maine, there are currently no caps on services for the vast, vast majority of children who receive main care. In other words, by using main care, you don't have a problem with running out of your insurance benefit. All right. Once you've talked with the parent and explained and worked through their insurance situation, and they've agreed for you to access their insurance, then that can be listed as the payment source for some of the services on the IEP. Now, there's one thing that we've got to touch on because I've seen it, and I know you don't mean to do it, but it happens. The right to a FAPE does not hinge on parents' consent to accessing public or private insurance, or any limitations on what that insurance will or will not pay for. A parent, a child, gets no different IEP because they have main care or because they have private insurance that will cover some or all of it. FAPE is an agreement between you as the education provider and the parent for the services to their child, and those services have to be at no cost, regardless of who absorbs the actual cost of them to ensure that the parent doesn't. Appropriate. I have to say, this is, not surprisingly, the issue that forms the basis of most of the litigation over IDEA. So what have the courts told us? Well, the First Circuit Court of Appeals, that's the step below the Supreme Court for people who live in Maine, has said that appropriate is a term of moderation, that it doesn't require the best or the optimal program. Nor, says the court, are you required to maximize the child's potential. On the other hand, the courts have been equally clear that an IEP, in order to provide FAPE, must provide educational benefit that is more than trivial or de minimis. In fact, the very last time the Supreme Court looked at the FAPE standard in 2017, they used very strong language. An IEP must be appropriately ambitious in light of the child's individual circumstances. So let's step back for a second, because when I say this, I can already get that sort of feeling in my stomach, and I'm guessing that a lot of you might have that feeling too. I don't go to work every day to provide not the best or optimal legal services to you and to my other clients. I go to work every day to do what I think are the best legal services that optimize your ability to be acting legally. Does that make sense? I mean, who of you comes to work every day to be, well, an implementer of moderation, an implementer of that of not best or optimal, but it's more than trivial or de minimis? That is one of the hardest parts of this. Of course you want to do what's best. Of course you give it your all. All I'm saying to you is that the educational standard that you're going to be measured against is whether or not the IEP provides educational benefit more than trivial or de minimis, but does not necessarily maximize the child's potential. Okay, so a little sideline about that. There are a couple of states that have actually amended their own state statutes to up the IDEA ante and specifically require IEPs to maximize a child's potential. We are not yet one of those states. Public. Okay. The hard reality is that a public entity, in this case CDS, is the only entity responsible for providing a FAPE. You can do that either directly through your own employees or by entering into contracts with private or other public providers. And I happen to know, as your lawyer, that you have a boatload of contracts with private and public providers. But, and this is one of those things that we accept because it's the way the world is, using a private or other public provider does not shift any of the legal obligation to provide FAPE onto those people. It's still yours. So why do you have these contracts, right? What's the point if it doesn't transfer the obligation to provide FAPE? Well, sometimes there's what we collectively refer to as a FAPE failure. And when there's a FAPE failure, you, CDS, are legally responsible to the parent for fixing it. However, under your contracts, you can, under the contract, deal with your private or other public providers if they have failed to honor their contract, and as a result, there has been a FAPE failure that's fallen on your shoulders. So the reason you have contracts is to make sure that in the event of a FAPE failure, should you wish, you can pursue your contractual remedies against the person who you thought was supposed to be doing the FAPE once you've settled the issue with the family about actually fixing the FAPE situation. Education. From the very beginning, Park and Mills, the two cases that we talked about seemingly forever ago, but it was actually like a month or so, the IDEA, in fact, no federal statute has ever tried to define for a state what a public education is. A public education is one of the most important things that each state defines and implements. So in other words, going state to state, you will find different definitions, different requirements, different concepts of what that public education means. But here's the key for IDEA purposes. A public education is what the state defines as appropriate for all students. In other words, it's the state's general education parameters around public education. And in Maine, we have the learning results. We also have Maine's early learning guidelines. And I know there's a group of people on this call from the Department of Education whose work involves working with both private and public pre-K programs and partnerships about the issue of what are you implementing in terms of your early childhood curriculum. Just to remember, the concept of a public education involves both academic and functional performance. In other words, a public education in Maine is more than simply what are the 4 areas of the curriculum that you're required to work on for X amount of time on X amount of days. Okay, so that same early case, Rowley, where the Supreme Court said it was confused about why they were there asking what is a FAPE. So they continued after noting that there was a definition right in the statute to say, we also think that this whole FAPE thing can be broken down into 2 questions. First, has the state or the local education agency like CDS complied with the procedures in the IDEA, the Act. And then second, is the IEP reasonably calculated to enable the child to receive educational benefit? And then they wrap it all up with a bow. We hold that the state or the LEA satisfies the FAPE standard requirement by providing personalized instruction with sufficient support services to permit the child to benefit educationally from that instruction. So that, according to the Supreme Court in 1982, and yes, think big hair, big shoulder pads, and Walkmen, is the very simple definition of how the state can comply with the IDEA. Not surprisingly, since the Supreme Court broke it down this way, this is why I think we should approach it first from the procedural standpoint and then from the substantive standpoint. So just to be clear, Endrew F had a significant impact on Rowley and on FAPE. So Endrew F bears at least a little conversation today and probably even more conversation next week, because it answers a question that I think is fairly important for a situation like you find yourselves in with CDS, and let me explain why. Endrew F was a student who in no way, shape, or form could be working on grade level. In other words, with all of the accommodations, modifications, and specially designed instruction in the world, Endrew was never going to be able to work alongside his typically developing peers. And as a result, the family and the school could never decide on essentially what was enough in the IEP. Unfortunately, Endrew's IEP for several years contained essentially the same goals. And every year, he wasn't meeting them, and so they carried over to the next IEP. And so it was sort of stuck in a stagnant place. In other words, the parents were concerned that unless something changed, no progress was ever going to be made. And the school's position was that merely by continuing to work towards those goals, he was making progress. Now, there's another thing about the Endrew F case that made it particularly interesting and probably the reason why it got to the Supreme Court. The circuit court that it came from, not the First Circuit, had said that the standard for FAPE was literally any educational benefit at all. In other words, they come pretty close to accepting the de minimis standard of educational benefit that our circuit, the First Circuit, had expressly rejected. So in other words, the case that the court took involved a circuit where the benefit required, according to that circuit, was pretty much nothing. In other words, really, really low standard. And so what the court was looking at was sort of a worst case scenario, if you think about it. All of these schools were creating plans for children who were significantly disabled. So they weren't able to work at or near grade level at all. And they were doing it to a standard of anything counts. The Supreme Court rejected that. And I think that pretty much everybody agreed that that was the right thing to do. In fact, it wasn't the thing that was being done in several other circuits. The court said, a student's IEP must be appropriately ambitious in light of his circumstances, just as advancement from grade to grade is appropriately ambitious for most children in the regular classroom. The goals may differ, but every child should have the chance to meet challenging objectives. Now, put for a moment aside the fact that the Supreme Court doesn't understand that goals and objectives are something that are specific terms in IDEA land. They don't know about that. But in a macro sense, what they're saying is, just because a student can't be measured in the sort of mainstream way that their typical peers are being measured doesn't mean you get a pass on coming up with ambitious goals and the chance to meet challenging objectives. So why do I think this is particularly important for you? Obviously, once we recover from the holidays and are back together in January, we're going to talk about LRE, and in particular, my observation, as well as the observation of others, that a large number of CDS students are served in restrictive environments. In other words, in environments not with their typical peers. And so in those cases, you need to be especially careful, like Endrew, that you have a way to calibrate these IEPs so that the children have the chance to meet challenging objectives, but not necessarily progressing at the same rate or quantity of progress that they would if they were being served in a typical education program. All right? Okay. So let's start with the first question asked in Rowley. Has the state, has the LEA, has CDS complied with the procedural requirements? Now, I think if you looked through IDEA, you could find approximately 5,001 procedural requirements. That is not the purpose of the rest of this session, both because it would be insane to try to circle around all of them, but also because what I'm reflecting back to you are the procedural requirements that are what I consider to be the big ones, the ones that end up in due process, the ones that when the state does a complaint investigation, people complain about. In other words, we're going to try to focus on the big, remembering that for each of these, you need to look carefully at MUSER to make sure you've got all of the little component parts that can go with it. So let's start with what I see as the number one procedural issue: parent participation. If the parent is not given an opportunity to participate in the development of the IEP, you are literally dead in the water. There is absolutely nothing you can do. You could make the best IEP that any of us have ever seen, and it will get thrown out in a minute if the parent did not have the opportunity to participate as a member of the IEP team. So what does that mean? Well, a couple of sort of lead-in things. First of all, parents are entitled to notice of an IEP team meeting at least 7 days prior to the meeting. Let's be clear about what the notice is. The notice has to give the parent a fair shot to know what the purpose of the meeting is, who will be at the meeting. In other words, you need to put out there as your notice a roadmap of what you expect to happen. Does that mean every bit of detail about what might be discussed? No, but it's got to be fair. So a hearing officer or a court will be extremely sympathetic if a parent says essentially, I went to an IEP team meeting that said, develop IEP, and next thing you know, I'm being told that my kid's going to be shipped an hour away because that's the only placement they have. See what I'm saying? So it's a no surprises notice requirement. The other thing to think about ahead of time is that IEP team meetings need to be at agreed upon times and places. So as you're setting up IEP team meetings, you have to be careful to consider the parents' needs and preferences in terms of when and where you're going to meet. Obviously, this year, you also need to discuss how this can be accomplished using alternative methods like a Zoom like this one, or something alternate, video conferencing, audio. In other words, some other way to satisfy the meeting requirement. And IDEA is clear that even without a pandemic, okay, IDEA didn't anticipate a pandemic, but suffice it to say that the ordinary course means that you can arrange for alternative arrangements along with parent consent at any time. So you set it up so the parent has the opportunity to participate. Now you've got to ensure that you have a properly composed IEP team. You know, we talked about this last week, and you know we talked about it the week before last week, but I think it's entirely possible that every week of this class, we are going to talk about the composition of the IEP team, because not having a properly constituted IEP team, again, best plan ever, not going to get anywhere. Any hearing officer or state complaint investigator, not compliant. So, parent, regular education teacher, special education teacher provider, the representative of the entity, CDS, qualified to provide or supervise the provision of specially designed instruction, knowledgeable about the general curriculum, and remember, that is the person who has the authority to obligate CDS. In other words, to pay for it. Also, at the discretion of either the parent or the SAU, other individuals who have knowledge or special expertise regarding the child. And as I told you last week, the only people that have been deemed not to be possible participants under this category is the press. An individual who can interpret the instructional implications of evaluation results. Whenever applicable, the child, and just to be clear, they're really talking about older children in that case. And just to remember, if you have a state ward or state agency client, the child's caseworker from the youth serving state agency is a member of the IEP team. So don't forget your DHHS representative. And just to be clear, that doesn't mean they're the parent. Participate, yes. Parent rights, no. So I just want to go back and say that I've been called unduly cynical, but I'm going to give you my take on the membership of the IEP team anyway, because I think that my case, well, let's just say, is supported by the litigation around IDEA. All of these people on the IEP team are important, and the courts have told us that failing to have one of these people can be a fatal flaw in your IEP. But you need to be realistic about this. The IEP team is dominated by two supernovas. One is the parent, and the other is the agency representative who's going to obligate CDS to the FAPE. If the parent and the school, or in this case, the parent and CDS, don't agree, that's a problem. And so, even though all of these people are important, you need to stay focused on the fact that ultimately it's the parent and the representative of the school that have all the cards in terms of agreeing or not agreeing and the due process rights that follow from there. Okay, a reminder from last week that IDEA has been amended and MUSER has been amended to allow non-attendees. A member of the IEP team is not required to attend in whole or in part if the parent and CDS agree in writing that the attendance of the member is not necessary because their area of the curriculum or related service is not being modified or discussed. I just want to be clear, I would never want to see an excused attendance of the parent. There's something that's not right in this if you're saying that the person who is being not required to attend the IEP team meeting is the parent. Now, the parent and CDS can make an agreement outside of the IEP team to change the IEP, to amend an IEP. That's allowed. But never, never, never show me a situation where the agreement is that the parent doesn't have to be there. That is just not good. I can't imagine that a hearing officer would buy that. Second part, excusal. A member of the IEP team being excused from attending where the meeting involves a modification to or discussion of their area. Again, parent and CDS agree in writing, and the member submits in writing to the parent and the IEP team input into the development of the IEP prior to the meeting. So next week, we're going to drill down on this. But one thing that I've observed about CDS is that at the moment, you seem to have a many hands approach to the drafting of the IEP. And next week, I'm going to show you and perhaps argue to you why it's very important that there be a synergy within the IEP that suggests that there really needs to be one person who's in charge of, at a minimum, making sure all the pieces fit together. So the idea that IEP teams will at some points have input in writing from people who aren't there is perfectly fine, but it means that you have to be sort of extra careful how you deal with making sure that the IEP that you end up with is consistent, cohesive, coordinated. Okay, so more procedural requirements. The IEP team has to consider the data obtained from the evaluations and assessments in shaping the IEP. One thing that pops up in due process from time to time, and it's really obvious when you have it, is if the hearing officer is presented with a pile of evaluations and an IEP, and the two things don't look like they have any connection to each other. In other words, you have no idea how you would get from those evaluations to that IEP. Bells should be going off all over the place. Second important thing to consider. The IEP team must consider the information provided by the parent, including evaluations obtained by the parent outside the IEP process. Now, last week we talked about what constitutes an evaluation for public agency purposes. In other words, if you were going to order an evaluation or accept an evaluation, it has to meet the standards of MUSER. That does not mean that when the parent shows up with the 2-sentence letter that I've made famous saying student is autistic, student needs 40 hours of ABA. That means that you consider it. You do not say to the parent, yeah, right. It goes in the pile of things to consider, and you consider it using the same evaluation that you put. In other words, just because the parent provides it doesn't mean that you can't scrutinize it and note that unlike your evaluation, this is a 2-sentence evaluation that appears to have no data behind it. You could ask the parent for permission to talk to the doctor that authored this brilliant 2-sentence letter. You could ask the parent if they have additional information that relates to the evaluation. In other words, don't start off on the wrong foot by simply saying to a parent that hands you information, meh, doesn't meet the standard. That doesn't mean that you have to accept it. In other words, it doesn't have to rule the day. So, words that should never appear in your vocabulary in the IEP process. We never do that. We can't do that. You get the idea? Anything that's an absolute is just a red flag. Now, you may know from a practical perspective that you have actually never used jumping out of an airplane as a manner to treat anxiety in a 4-year-old, right? I don't think any CDS site that I've ever worked with has said, yep, we're going to put skydiving on this IEP and we're going to toss them out of a plane. That'll cure them. It's still not always, never, can't. You will think to yourself, that is in fact not either special education or a related service, but you hear people out on things. I will tell you, although skydiving has never come up, I have heard more conversations about horse therapy and swimming therapy related to IEPs than I think I ever imagined in my life. Last thought, predetermination. One thing that is often alleged by a parent at due process is the meeting wasn't fair. In fact, the meeting wasn't even really a meeting. They had already predetermined what my kid was going to get. And so all the meeting was a rubber stamp of that. How do you avoid predetermination? There is nothing that prevents circulating a draft of an IEP or a proposal that can be added to the IEP. In other words, that is not in and of itself a violation, but you need to clearly mark it as draft, and you need to present it as a draft, and you need to actively solicit the parent's input about it. In other words, if you're at the meeting and you're looking at something that's been drafted by you, has been drafted by CDS, and the parent isn't responding, do whatever you can to prompt them. What is it about this that you like? Is there something about this that makes you nervous? Is there something about this that you don't understand? In other words, look for evidence that they've actively read it, absorbed it, are okay with it. All right, I have no idea why we've decided not to go forward, because I guess we want to do that. Okay, so Muser goes on for quite some time discussing how the goal of the IEP and the IEP team process is consensus. Now, remember, as an attorney, it took me a very long time and perhaps some therapy to talk about how great it is that the team is going to work to consensus. Because as you might imagine, when you have an IEP team and attorneys are involved, it is not, what's the word, a consensus state of mind that's going on there. But that is the role of the IEP team. It's a body that is charged with doing whatever they can to reach consensus about the contents of an IEP for the student. But here is the kick. Sometimes I watch you and you take the search for consensus to its bitter end and then some. If consensus is not reached, CDS has a legal obligation to finish the IEP and offer it to the parent. That is your offer of FAPE. You cannot be compliant with the IDEA unless you have made an offer of FAPE to the parent. And it needs to be as complete an IEP as humanly possible given the circumstances. What do I mean by that? I have seen cases where the school has tried its darndest to complete the IEP, but they're simply lacking information about the child because the parent is refusing to produce the child. That will not be held against the school. But what you need to do is everything in your power to deliver an appropriately designed IEP to the family, even if consensus isn't reached. You have to do it. At some point, continuing on with the consensus process becomes an IDEA violation, because if you haven't delivered the offer of FAPE, what can't you do? You can't get off the schneid and deliver the FAPE. And so you make the offer of FAPE, and the parent then has a choice. They can either accept the offer of FAPE or challenge it at due process. But in any event, it gives you a way forward. Don't not finish. All right, that sounded a little weird, but you know what I mean. Another important part of the procedural elements, the procedural written notice requirement. So you have to give notice to the parent of any decision to initiate or refusal to initiate any change to identification, evaluation, placement, or the provision of FAPE. Let's do that again. Any decision to initiate or refuse to initiate identification, evaluation, placement, or the provision of FAPE. Now we're going to see in a few weeks that those 4 categories, shockingly enough, are exactly the 4 categories that get you a due process hearing. There is a parallel there. Written notice covers the same ground as what the parent or you can bring to due process. What has to be in the written notice? You need to summarize the proposal, the decision or determination, and the basis for it, including evidence that the team considered and any alternatives that were considered and rejected. So let's think this through from a very practical standpoint. Written notice is your opportunity to review what happened at the IEP team meeting, what decisions were made, why they were made, and who had input into them, and what should be showing up throughout this written notice? The parent's input. A written notice that has no indicia that the parents either proposed something or were consulted or provided information. You need to use that as a thought moment for how was your IEP team meeting going. In Maine, the notice must be provided 7 days prior to making the change that you're describing in it. Interestingly, IDEA itself contains no actual deadline for that notice. Whatever. So I want to talk a little bit about Ms. M versus Falmouth School Department, because I think it brings us back to an important point about written notice. So in Ms. M, the dispute, to the extent there was a dispute, was about the methodology that was going to be used to deliver reading instruction to her child. And this was, let me just say, a long-running dispute. The school, understandably, refused to put in the IEP a methodology, because as you all know, methodology is generally reserved to the school to figure out by itself. This made the parent very unhappy. And so the school, in order to try to maintain peace, used the written notice to include what methodology they were going to use. Then the parent noticed that they were in fact not using it, and immediately went to due process and was waving the written notice around. The court, because this went all the way up into federal court, said a written notice is a means of communication between the parent and the school, but it's the IEP that is the binding document. In other words, she could have written notice talking about her preferred method of literacy instruction until the cows come home. What the school is obligated to do is follow the IEP. Okay, we're going to come back to those timelines. Eligibility is determined within 60 calendar days of receipt of the parent consent to evaluate. So that's when the timeline picks up again, right? You sent the notice out. Once you get it back, 60 days. The IEP is required to be developed within 30 days of the determination of eligibility. And in Maine, the IEP has to be implemented within 30 days of the determination of eligibility. Again, that's a Maine requirement, not an IDEA requirement. IDEA says the IEP is supposed to be implemented as soon as possible. So, just to make clear, you have 30 days after eligibility to develop and implement an IEP. What happens if you can't? If you're unable to implement the IEP within 30 days of its development or within 30 days from the start of the school year, if you have a student who's going to a regular education program that has a school year, you have to reconvene the IEP team to consider alternative service options. You also need to consider whether you need to amend the IEP if necessary to reflect the inability to commence services as originally anticipated. Last timeline reminder, there's no timeline for sending the written notice, except the parent has to receive it 7 days before the action takes place. And as Roberta reminds me, 7 equals 10. Yes, it's IDEA math. We all live with it. We all love it. So there are procedural violations of the IDEA, and there are substantive violations of the IDEA. Before 2004, there was plenty of case law that held that in order to find a deprivation of FAPE, the procedural violation had to cause some sort of substantive harm. In other words, you didn't get a deprivation of FAPE, or in other words, compensatory education, your tuition at the private school of your choice, you know what I'm talking about, simply because you were able to make a list of little things that the school didn't do right. Because, as we all know in our darkest days, I have yet to see the first IDEA process where any student has had exactly 0 procedural slips. I'm sure there is one out there, but the reality is, because of the enormity of the procedural requirements, something may go wrong. That does not mean there's a deprivation of FAPE. There's a case, though, ML versus Federal Way from the 9th Circuit. Now remember, 9th Circuit out in California, not the 1st Circuit, but that's really important because it makes a very important point for you to keep in mind. Now, ML was a student who had pretty significant disability, but was in fact attending a regular elementary school. The problem was that there were 2 IEP team meetings where there was no regular educator present. Now, this was before the amendment of the IDEA to allow for non-attendance and excusal. So we're talking about a flat situation where there's a member of the IEP team missing twice, and it's the regular educator. The school says, not an issue. Because really those IEP team meetings, I mean, this kid isn't really close to the regular education environment, even though they go to a typical public school. Not so, said the court. The regular educators being missing just doomed the entire process. The court said the entire purpose of the IDEA is to create appropriate education programs that are effectively cantilevered or scaffolded off the regular education program. And to simply say, we don't need a regular educator there is wrong, and it poisoned the entire IEP process. So think about that when you're thinking about what are just procedural problems versus substantive harms. Now, in 2004, the IDEA was amended, and of course, it added the attendance and excusal provisions, but it also added the specific requirement that a hearing officer determination of whether a child receives FAPE must be based on substantive grounds. If allegations of a procedural violation are what are being made, a hearing officer may find a violation of FAPE only if the procedural inadequacies impede the child's right to FAPE, significantly impact the parent's opportunity to participate in the decision-making process regarding the provision of FAPE, or cause a deprivation of educational benefit. And to be clear, hearing officers have held that failing to provide written notice, things like failing to offer the parent alternative times and methods for attending an IEP team meeting, things like that significantly impact the parent's opportunity to participate. And once you have that, then you have a procedural inadequacy that leads to a substantive denial of FAPE. So next week, we are going to dig in hard on what is this substantive denial of FAPE. But as promised, FAPEcat's special code, once again, not a particularly creative effort by FAPEcat, but he's very busy, like I said, preparing for his holidays. Anyway, Roberta, since Aaron is not with us, are you going to be the comment moderator?
I am, and we do have some questions in the chat box, Sarah.
Okay, hit me. I mean,
sure. So Jane Durgan says, I'm wondering if FAPE is exactly the same now as before the pandemic. I'm curious about the issue of equity. Students in my district have modified schedules with various degrees of remote learning. Public education has shrunk. You changed the screen, so I lost my place.
Oh, geez, sorry.
That's okay. Public education has shrunk. So does FAPE fall in line with the new structure? Can you speak to this issue?
Gee, well, that's only like the biggest issue that we're all facing.
I know, in this pandemic.
Sometimes you hit the nail right on the head. So I have a lot of thoughts about this, as you might imagine. Probably too many for a simple answer, but let me give you a few tips or thoughts. One is that the U.S. Department of Education has been clear about two things, and frankly, in my opinion, they're inconsistent. I know, shocking, those who know me, that I would think that the U.S. Department of Education is somehow failing. First, the U.S. Department has been very clear that nothing about IDEA contains a, quote, pandemic exception. And second, they have pointed out to us innumerable times, all in guidance, and what is guidance? Not law, that IDEA contains many flexibilities. Okay, after the last hour, are we all feeling like IDEA has many flexibilities? Yeah. Anyhow, so, for example, there has been a general acceptance of the fact that where there is a public health order that prevents schools from operating in person, there is no obligation to provide FAPE in person, even in situations where you and I and the IEP team all know that this student is not going to benefit, either in whole or in part, from remote instruction. What is the answer if you have a situation where you are not holding classes because of a public health order and you have a student who is not benefiting? It means you're going to have to wait it through, and then you are going to have to devise a compensatory education program that will allow the student to make up for the lost time and services. But Jane is asking about a trickier system because most of our schools are not 100% closed and there are no bans on ever having in-person anything. Instead, we're just changing the way that we deliver educational services. And so I know it's not going to surprise you that you need to consider for your students what of the typical educational program that other students are accessing is appropriate given their specific individualized needs and what is not. You may need to revisit your IEP, or you may not need to revisit your IEP. You may simply be able to move the services in the IEP to not 100% in person, but still done remotely in a manner that's consistent with the essential substance of the IEP. So I've heard a couple of things, one done by Disability Rights and another by another advocacy group, that essentially said nothing has changed. Well, that's just flat wrong and they know it. But their point is an important one. FAPE in a pandemic is still FAPE. In other words, we can't ignore the students for whom these new means of remote instruction, alternative instruction, don't meet their needs, even if it means we have to reconsider it after the fact. So I hope that was helpful. It was a little long-winded, but trust me, I could probably do an hour on that.
And maybe you will later down the road. We'll see.
You just never know what might happen. I mean, FAPEcat might actually behave for a whole hour consistently.
Okay, next question is from Jennifer Metcalf, and she says, if a child has DHHS caseworker and resides with Grammy, does CDS need a signed authorization to share information and records signed from the family guardian to speak to DHHS about services of that child?
Okay. DHHS is a participant at the IEP team. They're a member of the IEP team. So that means you don't need the same consents that you would need if you were accessing another third party. Does that make sense? So DHHS, they do not have the rights of the parent. In other words, they don't get to make any of the decisions that are reserved to the parent. And I'm going to go back to this because I heard another case of this last week. Oh, Rebecca, FAPEcat's friend is here. Anyway, no, they don't get to decide what evaluations happen. Who gets to decide whether to consent to an evaluation? The parent. Anyway, but they are entitled to information and they are able to have discussions about the child's educational program in FAPE just because they're part of the IEP team.
So if they're in state custody, Sarah, they maintain guardianship, correct?
A child who is in state custody, the legal parent is the Department of Human Services, Health and Human Services. But again, there has to be a surrogate parent appointed, correct, and it is that person who holds the parental rights. Now, DHHS knows this. We train on this. My colleagues at the AG's office are really fantastic. If you have problems with particular offices or caseworkers, let me know. I'll work through my colleagues. They'll do another training with their folks because they know how important this is. But yeah, they are the legal custodian, the legal guardian of these children, but there has to be a non-state person, correct, yep, the surrogate parent.
Next question. How do we implement within 30 days if we don't get the initial consent back?
Okay, so remember, we're working on a timeline here, right? In other words, whenever something is contingent on the parent providing consent for it. You don't have a timeline problem if the parent doesn't return the consent. You have a problem if you have the consent and aren't hitting the numbers.
Yes. Great. Next question. If the IEP admin for the meeting holds dual certification in both regular ed and special education, does that cover the need for a regular educator in both initial and annual IEP meeting? And I think we asked that question a couple times ago.
I think what my answer was, although, you know, it's totally lawyer-esque to be able to give different answers every time, it's very good to keep the meter running. Oh, I don't have a meter. Anyway, it would be very good to keep the meter running. But anyway, yes, you can have one person fill more than one role, but again, be careful, right? If the IEP team meeting is between the parent and a single representative of CDS who is the regular educator, the special educator, the person responsible for obligating CDS, and the person who can interpret the results of the educational implications of the evaluations, I'm just going to say that it doesn't have that team-like flavor. And even though I've admitted to you in a recording about the two supernovas of the IEP team, that doesn't mean you should do things that, what's the word I'm looking for, enhance the possibility of them being the only novas.
Okay, we have a very long comment question, I think, from Karen Baldwin, and it might be advantageous for you to look at the chat box because it's almost near the end. And instead of me reading it to you, because it's about section 65 and 28, and I'm not sure that you know the complete answer to this question. Do you see it, Sarah?
Oh yes, I'm reading.
Okay.
Okay, I think I get some of what's going on here. So let me start by giving you what I refer to as the 2 rules of main care. Rule number 1, if you don't think it's required for FAPE, it does not go on the IEP. Shall we all say that together? If not FAPE, not on IEP. You need to practice saying that because sometimes DHHS will want to push you in that direction. Not necessary for FAPE, not on IEP. The second rule of main care, related to the first, never try to tell main care that they cannot do things outside of the IEP, but don't look to us to deal with any of the fallout from that. In other words, main care will snap like a snapping turtle if you try to say it's the IEP and only the IEP. They will tell you 15 times that these families have the right to anything their doctor says they need or anything their someone says that I don't even know who says who needs what. That's fine. But the second refrain to main care is, but don't expect CDS to deal with the fallout from those outside the IEP services. So in other words, if you're ticking along just fine with the IEP ordered 15 hours a week and the parent gets mad because they only ended up with 25 instead of 30 or whatever, that is not your dispute. So there's another thing hiding behind this question. And I'm sorry that Erin isn't here today of all the days because she and I have talked about this.
She's listening. She's on the phone. She just can't see the questions.
Oh, hi, Erin. Glad you're on the phone. Best regards. Sorry about the back. Anyhow, there is an issue between what CDS is writing for FAPE and commonly held medical and educational views about the number of hours of ABA and similar programming. Now, you are writing based on Muser that tells you that we're trying to figure out what a typical educational day would be like for a typical preschooler, right? Because when you get to big school FAPE, you don't just write for anything. You write based on the fact that big schoolers go to school from what, 8 in the morning to 2:30 in the afternoon, 8 to 3, something like that. So what Muser says is that there is a presumption that 4-year-olds do three mornings a week and 3-year-olds do 2 mornings a week or something like that. Right, Roberta?
Yes.
So anyway, that is a presumption, and it's a way to try to deal with the issue that there is not the same level of standardization in early childhood programming that there is in K-12. That having been said, it's a presumption. In other words, a team can consider the specifics of having a particular methodology or a particular program or a particular need that does not fit neatly into 3 mornings a week. So know what a presumption is. In other words, it's the place that you start until you have evidence to rebut it. Anyway, I know we will have more conversations about this, but when I saw your question, I couldn't help think that part of this issue involves the 2 rules of main care, but the other part of the issue needs to do with how you properly write IEPs for students that are working on that.
Okay, we have a couple more questions.
All right, keep them coming.
Can you explain the 7-day written notice and the 30-day IEP again, please? Timelines of parents receiving versus completing the paperwork.
Okay, so 7-day written notice means that you have to send it to the parent 7 days before you plan to make the change described in the written notice. Okay, now, just to be clear, the parent can waive that in writing and say, oh, no, I'm all in and I want it to start tomorrow. But I'm sorry, 7 + 3 is 10. You send it out. That's the amount of time before you can actually do the action. 30-day IEP. You can develop the IEP, and we talked about this morning. You can send the IEP out with the written notice, but what is the important thing you have to do to the IEP? You have to make sure that the implementation date on the IEP, the effective date, is at least 10 days out. 7 + 3 = 10. Okay?
Allowing for mailing.
So you do not have to do 2 separate mailings, one of the written notice and then one of the IEP. If you want to do them together, you have got to deal with the issue of setting your date on the IEP so there is no evidence that you're insisting on implementation before the written notice, period. Does
Great.
that help?
Yep. Tammy Baralt has a comment. Like many of us on this webinar with you, I'm a director of a pre-K to 12 district. Many of the topics you are digging into in the weeds is super helpful and informational, but there is, of course, huge overlap between Part B and Part C, which is the same when much is the same, and then there are distinct differences. You can't do this now, but it would be super helpful to have something from you that highlights from your experiences the things that can get easily confused. So just a thought about thinking about Part C to Part B.
Okay, so the reality is that I feel a little bit guilty. I don't know, it's holiday guilt, it's whatever. that we've got this thing going now for the B operation of CDS, but not the C operation of CDS. So there might have been suggestions of a promise that in the new year, I will work with the C side of the house, so to speak, to see if maybe we do something similar in C land. But I absolutely get, Tammy, that there's a separate thing in there, which is the moving from B to C. I mean, from C to B. Geez Louise, only, what is that movie about the guy, you know, Brad Pitt, and he like got younger instead of older. Anyway, I focused on the Brad Pitt part. Oops. Anyway, one thing that I've not had enough time for in all of this is to hone right in on the transition from C to B. I mean, mentioning as part of the referral and child find that you had all these kids under your nose because they were in Part C is really not adequate to explain the specifics of the C to B transition process. So that's on the list too. Benjamin Button, yes. Brad Pitt, anyway.
Okay, next question. How do we use the standard 2 mornings or 3 mornings a week if the public pre-Ks generally go 5 times a week and often all day?
Okay, so this is a controversial view from your lawyer. I would be very careful holding to the rule of the 2 mornings a week or 3 mornings a week if a regular education student in that child's district is going 5. Because remember, we're really going to talk about this with LRE. In our imaginary world, as opposed to our reality, the way you talk about LRE is you picture twins, one is a student with a disability and one is not. Where is the child without a disability spending their day? And if the answer is they're in a district where they're spending their day 5 mornings a week in public pre-K, and you're going to say that the disabled or the twin with a disability is going to have 3 hours 3 times a week, I want you to be careful about that. I have to tell you, it's a bit of a mystery to me. Again, recording, but whatever. Parents in Maine are amazingly accepting of the various ways in which CDS puts together FAPE programs. But I keep waiting for a parent to say, I'm not really sure this is aligned with what my school district is doing for non-disabled preschoolers. And during LRE week, we should talk about that because it's a super, super critical relationship that you all have with your early childhood professionals in the public school districts that are doing these pre-K. Simply because CDS has the legal obligation for FAPE for 4-year-olds and 5-year-olds, preschool age 5, doesn't mean that they get a different access to public education in districts where they offer public education to those ages.
That's it right now, Sarah. We're all done.
That's everybody's question.
That is everybody's questions.
So next week is another biggie. We are going to tackle the substance of FAPE. In other words, what is it that makes your IEP deliver a FAPE? And what is it where I can look at your IEP and be like, you know, I don't know one thing about early childhood development, OT, PT, or speech, but I can guarantee you this isn't FAPE. All right. Have a good week, everybody, and we will see you next week for a pre-holiday FAPE Fest.